Hey guys, Joe Brunsman here from Chesapeake Brokers, back with what appears to be a very spicy court case. This is in the matter of First America Title Insurance Company, brought by the New York State Department of Financial Services, also known as NYDFS, or DFS for short. This particular case, I believe, is actually the first case brought under 23 NYCRR 500, which makes this particularly interesting to all of us cyber law nerds out there and cyber insurance guys. So let's go ahead and jump into the case. Hopefully we can all learn something from this. So starting off here, we have the statement of charges and notice of a hearing. Not particularly interesting there, but really just saying, hey, whether these violations should be found for respondents' persistent failures to safeguard customer information, and whether civil monetary penalties shall be imposed and other appropriate relief granted as a result of such findings. So this could get interesting. Let's look at the overview of this particular case. So for more than 4 years, First American, also known as First American Title Insurance Company, and these are all allegations, I will say, according to Department of Financial Services. These are allegations. I have not yet seen the response from First American to these allegations. So allegedly, going further, they exposed tens of millions of documents that contain customers' sensitive personal information, including bank account numbers and statements, mortgage and tax records, social security numbers, wire transcription receipts, and driver's license images. All of those considered NPI, non-public information, under 23 NYCRR 500, and under various other statutes known as PII. So from at least October of 2014 to May 2019, so quite a long period of time, due to a known vulnerability on their public-facing website, these records were available to anyone with a web browser. By permitting a URL on its public website to be vulnerable to manual manipulation or rewriting, they apparently laid bare millions of personal data points on its customers. And allegedly, this went undetected, this vulnerability, for years. The respondent, so in this case, First American, mishandling of its own customer data was compounded by its willful failure to remediate the vulnerability, even after it was discovered by a penetration test in December 2018. So kind of an interesting anecdote here. Yes, you probably should be doing penetration testing, or at least for most businesses. Now, once you find what those vulnerabilities are, those are going to be of different severities, right, or differing severities. So some will be a high severity, some are low severity, but you at least need to have a plan in place on how you're going to fix those particular vulnerabilities. We're going to get in, we're going to see whether First American responded to this particular vulnerability appropriately. So let's talk about the role and jurisdiction of Department of Financial Services, DFS. So they're bringing this under 23 NYCRR 500. It requires covered entities to implement and maintain cybersecurity policies and procedures to address, to the extent applicable, consumer data privacy and other consumer protection issues with effective controls, secure access privileges, thorough and routine cybersecurity risk assessments, comprehensive training and monitoring for all employees and other users, and well-grounded governance processes to ensure senior attention to those important protections. So of course, 23 NYCRR 500, if you've never dug into that, it is quite expansive and actually has a number of kind of different levels depending upon what you're doing and the size of your business on the controls and all of the specific things you're supposed to be doing as a business. Now, also inside of this particular statute, they're very particular that this is a senior management problem. So this is not something that senior management can necessarily blame on low-level employees. These are issues that have to be brought up and actually briefed by senior members of the team. Now, every covered entity is required to base its cybersecurity policies and procedures on risk assessments to ensure ongoing evaluations of the risk that continuously threaten the security of non-public information, including sensitive personal information, and to further safeguard the information systems that are accessed or held by third-party service providers. So this brings in kind of another interesting concept here that a lot of people aren't familiar with. That's actually the subject of another video I'm coming out with here shortly. And that is, are you responsible for the security of your service providers? If a service provider gets breached, who is actually responsible for the cost of that breach? and all the resultant legal issues that could revolve around that. It also goes further to say encryption and multi-factor authentication are further controls required under the cybersecurity regulation to ensure that covered entities thoroughly protect their customers' private data. So in this instance, hey, here's just another cybersecurity requirement if you fall under this statute where you have to be doing encryption and MFA, multi-factor authentication. All right, so what is a covered entity under 23 NYCRR 500? It's rather vague, actually, if you read the statute. I think kind of the gist of it is, and obviously not providing insurance advice here or legal advice. I'm not your attorney or insurance guy, but it's generally going to kind of fall into three buckets. So if you are licensed or regulated in the state of New York for banking, financial services, or insurance, you fall under 23 NYCRR 500. Now, NYCRR 500, as I mentioned before, is a very kind of interesting statute for a number of reasons, one of which it doesn't use the term PII as most other statutes do, which is personally identifiable information. Here, they use something called NPI, which is non-public information. And you can read through that at your leisure or look up the actual statute, but it's fairly analogous to what we think of as PII in other statutes. So let's get into the factual allegations, right? Underline factual allegations. These are allegations made by the Department of Financial Services. So as we scroll through, what does First American actually do? Well, they collect, store, and transmit the personal information of millions of buyers and sellers of real estate in the U.S. each year. First American stores this information in its main document repository, the Fast Image Repository, also known as FAST. So why is that important? Well, FAST includes tens of millions of documents with sensitive personal information such as social security numbers, bank account and wiring information, mortgage and tax records. In April 2018, for example, FAST contained 753 million documents, 65 million of which had been tagged by respondents' employees as containing non-public information. And then interesting, a random sampling of 1,000 documents that were not tagged as containing NPI showed that 30% of those documents actually did contain NPI. So now we have a classification issue that's going on here. As of May 2019, FAST contained over 850 million documents. Now, First American also created and maintained an application on its network known as EaglePro. This was the web-based title document delivery system that allowed title agents and other employees of First American to share any document in FAST with outside parties. EaglePro is intended to be used by title agents and others to share the title package with the parties to a real estate transaction. So that could be a number of different individuals there. If anybody has ever had the misfortune of going through the mortgage process, there's a lot of party involved. After a party to or a participant in the transaction selects documents from FAST to be shared with another participant of a real estate transaction, EaglePro emails the recipient a link to a website that allows him or her to access these documents. Anyone who had the link or the URL for the website could access the package without login or authentication. So obviously that's going to be a problem there. You would just kind of presume that, okay, we have a lot of sensitive information here. They could lead to identity theft. Maybe the least we'd want to do is at least have, say a login, a username, a password before we actually view those records. But allegedly, First American did not do that. So let's get into the data exposure. In October 2014, the respondent updated their EaglePro system in a manner that gave rise to a vulnerability. That kind of the interesting lesson there is to realize that, cybersecurity is not a destination, it's a process. So as your system is changing, you need to continuously go back and reassess what those potential vulnerabilities could be. So it sounds like here that, at least beforehand, this was a vulnerability that possibly didn't exist prior to October 2014, but then they updated their system and that brought rise to the vulnerability. The URL for each website shared via EaglePro included a document ID number, and each document in FAST was assigned a sequentially numbered ID. By changing the document ID number in the URL by one or more digits, anyone could view the document corresponding to the revised document ID. As a result, by simply typing in any image document ID, Any document in FAST could be accessed regardless of whether the viewer had authorized access to those documents. Until May 2019, the URL shared via EaglePro had no expiration date. So a number of issues there. It sounds like it was subject to something called a SQL injection attack or an SQL injection attack. And also the fact that these had no expiration dates is troublesome, or at least the allegation is troublesome, because you would just presume that, eventually, hey, we don't need to have this information available anymore. Maybe we should have an expiration date for these documents. It'll be interesting to see if there was some sort of rationale behind why EaglePro had no expiration date. I can't really think off the top of my head of any particular circumstance where I would need to go back into that system, or some other party would need to go back into that system specifically, say possibly a decade later, and look into that information. Now, going further, they allege that more than 850 million documents were accessible to anyone with a URL address, providing access to a single document in the EaglePro generated website. In December of 2018, First America's cyber defense team discovered this vulnerability during a penetration test of the EaglePro application. So, first off, kudos to First American for actually conducting a penetration test. The question is, okay, what did they do with this information now that they've discovered this vulnerability? Well, in an email on December 2018, a member of the cyber defense team alerted the application development team to the existence of this vulnerability, saying, quote, recently discovered important findings during the reconnaissance phase of our current penetration test of the EaglePro application that should be addressed. So that could be somewhat innocuous. Let's go further. Then it went on to describe the vulnerability. So not really out of the woods there. Recognizing the urgency of the situation, the manager of the application development team responsible for EaglePro replied that the vulnerability should be, quote, addressed as soon as possible. So it sounds like here, going all the way back to 2018, they were like, hey, we got a problem here. We need to have this fixed. Now, this penetration testing team, this internal team, distributed the final report, and it described the vulnerability in detail, including pages of screenshots demonstrating how this EaglePro website could be manipulated to display sensitive documents not intended for widespread viewing. This report also showed more than 5,000 documents exposed by EaglePro had been subjected to Google search engine indexing, i.e. collection and storage of data by Google, to facilitate later information retrieval in the course of open source Google searches by the public. That's a big deal if that allegation is true. Also within this report, they had the following warning, quote, using standard internet searches, we were able to bypass authentication to retrieve documents that were found using Google searches. Now that's a pretty damning allegation there, that someone could just get all this information and it was potentially readily exposed via a quick Google search. Even more alarming, in the 6 months following the discovery, allegedly First American failed to correct this vulnerability, even though hundreds of millions of documents were exposed. This lapse was caused by a cascade of errors that occurred substantially due to flaws in respondents' vulnerability remediation program. So kind of a good takeaway there is, if you're watching this and you actually have a vulnerability remediation program, it's actually worth just going back and reassessing that vulnerability program every now and then, just to make sure that, employees, they come, they go, and then everyone's, singing on the same sheet of music there, so that those vulnerabilities actually get patched and updated as soon as possible. So other allegations here, the respondent grossly underestimated the level of risk associated with the vulnerability, and apparently the problem was erroneously classified as medium severity. So obviously this would have been a high severity vulnerability. It looks like it was erroneously classified as a medium severity vulnerability. They failed to follow their own cybersecurity policies. They conducted an unacceptably minimal review of exposed documents and thereby failed to recognize the seriousness of the security lapse. So what they're saying here is that internal team only reviewed 10 documents out of the hundreds of millions that were exposed. So they're saying that's an issue. They're saying the First American failed to heed advice proffered by its own in-house cybersecurity experts. And then apparently there were administrative errors that compounded this whole thing, specifically in the time frame needed to remediate this vulnerability. The director of the cyber defense team, ostensibly here at First American, inadvertently caused additional delay in the remediation by accidentally reclassifying this vulnerability from medium to low severity when it was entered into the tracking system. Now, with this new classification of low severity, that means that they had 90 days to actually remediate that particular vulnerability. But then apparently, adding insult to injury here, that was actually delayed for another 6 months. All right, going on. Remediation, once it was assigned, was ineffectively assigned to an unqualified employee. So that's another alleged mark against him. And also, apparently, First American actually knew that its procedure to identify and classify sensitive documents in this FAST system was just inherently flawed. So to identify and classify sensitive documents containing non-public information, aka PII, apparently First American relied solely on a process in which title agents, in the course of uploading documents, manually added the prefix SEC to the name for each file containing MPI. Now, anytime you have humans involved, obviously there's going to be error. In this case, probably could have had an automated system that would actually go through and search for, potential driver's license numbers or social security numbers, anything that contained PII. That probably would have been a better idea than simply relying on a title agent to manually enter the classification of this data there. Now, in April 2018, a presentation by senior members of respondents' IT and InfoSec management team to the board of directors demonstrated that within a random sample of 1,000 documents stored in FAST, 30% of those documents contained MPI but were not tagged as such. So you have to remember they have somewhere between 700 million to 800 million documents on their system. If you have a 30% error rate of 800 million documents, that is a vast number of documents containing MPI, and really just, at least allegedly, running completely flagrant of the rules here. Now, on June 1st, 2019, there was an email from First American's Vice President of Information Security discussing problems with MPI controls in Eagle Pro. They likewise acknowledged that the manual process for designated MPI was, quote, highly prone to error. So at least they recognize this problem, but did they actually do anything about it? Well, the staff responsible for Eagle Pro's application security, that being the Director of Vulnerability Remediation Management Team, the Director of Application Security, and the Eagle Pro Accountable Remediation Owner, testified they were not aware that MPI was transmitted using Eagle Pro, or that a 2018 sample of documents in FAST had revealed a significant error rate in the tagging of documents with MPI. Well, let's just pose a question. Do you find that feasible, that all of these people dealing with Eagle Pro's application security didn't actually understand what Eagle Pro was being used for, or that MPI was being transmitted over the system? I find that questionable, to say the least, if the allegations are true. So in June 2019, a journalist publicized respondents' data security vulnerabilities. The respondents' information security personnel recommended modifying Eagle Pro, limiting access to authenticated users. Senior management rejected that recommendation. So now it looks like senior management could get in trouble here. First American's information security personnel then recommended adding 2 technical controls to protect MPI. So it looks like they're trying to do the right thing here. First, they recommended disallowing transmission of tagged MPI documents in Eagle Pro via unsecured links. Definitely a good idea. Second, in recognition of the faulty nature of manually tagging documents, they recommended a scan of FAST documents containing MPI but not tagged as sensitive. So obviously, 2 very good ideas here. They sound completely reasonable, and something that I think any InfoSec professional would probably recommend, but allegedly neither recommendation was implemented. And according to DFS, to this day, the sole control preventing Eagle Pro from being used to transmit MPI is merely an instruction to users to not send non-public information. That's, if true, that's pretty atrocious. That's pretty terrible. I find it hard. I think First American generated something in the nature of like over $6 billion, something around there last year. So surely a company of that size would have the budget to actually fix a problem of this magnitude. So when the Department of Financial Services asked First American's CISO, the Chief Information Security Officer, why additional controls were not adopted to protect NPI, apparently the CISO disavowed ownership of the issue, stating, amongst other reasons, that such controls were not the responsibility of First American's Information Security Department. I find that pretty hard to believe. I think that New York Department of Financial Services probably doesn't believe that either. And, whether true or not, eventually someone's got to be responsible for this. And it seems entirely reasonable to me that the CISO would be one of those individuals that's responsible. Now, if you're a CISO and you're watching this, or you have any insight to that and I'm wrong, please let me know in the comments below. All right, further allegations. They also failed to timely encrypt documents containing MPIs required by 23 NYCRR 500. So in May 2014, 2019, Brian Krebs, if you're not following Brian Krebs, probably the preeminent journalist on cybersecurity issues. Anyways, he published an article revealing that First American had exposed 885 million documents dating as far back as 2003 and many containing NPI by rendering the documents open, accessible to the public. In the days leading up to the publication of his findings, Mr. Krebs and another individual who had stumbled upon the vulnerability repeatedly reached out to First American to alert the firm of the vulnerability. Now, I don't know if First American actually acknowledged Brian Krebs or not. We'd have to go check out Brian Krebs' website. But anyways, after the disclosure from Krebs, First American conducted a forensic investigation into data exposure attributable to the vulnerability, but was unable to determine whether records were accessed prior to June 2018. Okay, why is that? Well, allegedly here, their forensic investigation relied on a review of web logs retained from June 2018 onward. So it seems strange here that, their logs only went back to 2018, but they didn't have any process in place to actually revoke access or remove documents that were, potentially no longer needed on their system. Their own analysis demonstrated that during this 11-month period, more than 350,000 documents were accessed without authorization by automated bots or scraper programs designed to collect information on the internet. Now, what would a bot or scraper be? That could be, as mentioned earlier in these allegations, it could be a web browser. A search engine such as Google. It could be, a malicious third party who's going around trying to find any publicly accessible social security numbers that are available. Next, we get into the specification of charges. These are pretty straightforward, right? All it's really saying here is, hey, they violated a number of sections of 23 NYCRR 500. Kind of go through some of the fact pattern there and why that's applicable to various parts. All right, now finally here, this gets into really kind of the juicy part. So please take notice that as a result of these charged violations, the department is seeking the following relief: civil monetary penalties. It's kind of up in the air right now. Looking at various sources, I published a whole chapter in my book, both my books actually, on 23 NYCRR 500, and it's not entirely clear on what those civil monetary penalties could be. It could be quite sizable, though. So in some instances, people are saying, hey, it could be up to $1,000 per day per violation. It could be some percentage of the revenue. It's going to be pretty interesting to see kind of how this plays out. But needless to say, if you think you fall under 23 NYCRR 500, or you actually fall under 23 NYCRR 500, you really need to consider reaching out to legal counsel, going through this court document in greater detail, working with those InfoSec professionals to make sure that you're actually adhering to the law. And, of course, if you do actually find vulnerabilities in your system, make sure you actually have a way to manage those vulnerabilities and patch them appropriately. Go back through that vulnerability management system, every now and then with all the key players. Make sure everyone's singing off the same sheet of music and hopefully you guys can stay out of trouble. It'll be interesting to see how this case actually plays out. In the meantime, I'm Joe Brunsman. Hope you enjoyed this. Like, subscribe, comment, etc., etc., etc. Stay safe out there.